When you do your notice of understanding and intent, it's their opportunity to discuss it with you. If they refuse to discuss it with you, they are accepting your understanding. They are sharing this understanding. Because you now have a shared understanding, you can share with them your intent. Once you've shared that intent with them, you give them 10 days. If they raise no dispute with this, you now hit them with a claim of right. They have 10 days to dispute that claim, and if not, it's cured. From that point forward, every time you're doing whatever it is you mentioned in your notice of intent, you are operating upon a right and upon a claim of right, which is very important. Read section 39 of the Criminal Code. The claim of right allows you to use, either you or your authorized agents or representative can use whatever level of force or violence is necessary to protect whatever property you have, if you are holding it under a claim of right, even against those who are legally entitled to seize and possess it, which means cops. If they want to come and seize your property and you are operating upon a cured, perfected claim of right, they can't use violence to seize it, and the reason is the existence of one excludes the other. You cannot have two parties both with the power to use violence to seize one property. We're not fighting cocks in a ring here. We're not here to bring them pleasure by watching us fight. The fact that I can use violence to protect my property means nobody else has a right to use or threaten the use of violence to remove it from me. When you start acting on a claim of right, from that point forward, you are the one in power. You are now, instead of going to your employers and asking them permission to engage in an action, you are now claiming the right to engage in that action without asking them permission. Now who has the power? They can't remove it from you because it's a claim, it's not a permission. I have an enormous understanding of the law. It took me a lot of time to get here. The good thing about the notice of understanding and intent, you don't need the same level of understanding. Whatever understanding you have now is enough for you to act upon. If you recognize this is too confusing and I don't understand it, that could be your notice of understanding. Here's what I understand. I don't understand any of your words. That's good enough. Some of the words that I never found in their act, 3 words that I searched for, never found them anywhere. Love, compassion, and truth. Try to find those in any statute, regulation, order, or bylaw. You aren't finding them. If, however, you choose to live your life with love, compassion, and truth as your guiding principles, who are they to claim that this body of words has anything to do with you? They're not. A notice of understanding and intent can be as big or as small as you want to make it. I like to make it big so that there's all these different points on it, and in our packages over here we do have an example of one. Essentially what you're doing is you are going to, this is what it looks like, a notice of understanding, intent, claim of right, and a fee schedule. A fee schedule is essentially when a government agent, a cop or anything starts and puts an order upon you. They've got a gun there, you're going to be doing what they tell you to do. However, they might not have the legal right to do it, but they've certainly got force. You don't want to get beat up. So what you're doing is you're going to operate under protest and duress. I got 2 minutes and we're going to take a break and change the tape there. If you are operating under protest and duress, someone comes and says, you clean my floor over here. And you say, show me a contract. No, I've got a gun. Okay, good enough, but that's not a contract. It's going to get your floor clean, but you have 3 days after I wash your floor to show me a contract that says that I have an obligation to wash your floor and that you have a right to use a gun to get that contract fulfilled. If you don't do that within 3 days, guess who gets to determine the terms of that contract? You. That's what the protest means. You are protesting it, you're operating under duress, but then you get to decide, well, I charge $1,000 per square foot for cleaning your floor. There you go, here's my bill. When you tell them I'm operating under protest and duress, they will say noted. If they refuse to note it, you know that they're scared. And I'm not noting that. Okay, that's fine. But every time I've ever done it, I've done protest and duress. So then I got the cop, number 2191, I got him put on notice because I was operating under protest and duress. I have a record of doing that. And then when he arrested me, I told him and he refused to note it. No, I'm not putting that in. Well, sorry. I've got history as doing this. So when I come up and I wrote up and I said I operated under protest and duress and he wouldn't accept my protest, that cop was in shit. He can't lie like that. Okay. Well, we're moving back on. One of the things, using a notary, notice of understanding and intent. If you are going to do this, you need a notary public. The purpose of the notary public is to help you avoid conflict. You can use a lawyer to win conflict. You use a notary public so you can avoid conflict. In the Freeman package, there is directions to a notary public. Now, I've had trouble trying to get notaries to do what I want them to do. I've had a few that tell me, oh, well, although the Act says that they may protest or attest or protest any commercial or other instruments, they try pointing out and saying, oh, the word is may and therefore it's permissive, therefore I don't have to do it. My argument with them at that point was, and they tried claiming, oh, I don't know how to do it. I said, well, they've given you permission to do something that's very important to us, and yet you haven't even gone out of your way to figure out how to do that yet? I think you should lose your notary license. Okay, she reached in the bottom of her drawer, pulled out a protest stamp. She had it all along. They just don't want to do the protest. They have to do it. We've got a great notary public now. I imagine you could use him if you needed to go to Vancouver. His name's Kwan. He had his oath up on the wall, and he also had a Christian quote. So I asked him, I said, so you believe in Christ? He said, I sure do. I said, and you believe you took your oath seriously? Sure did. I said, you know the Queen's oath? Oh, yeah. I said, so you're protecting the faith is what you're doing. When you protest instruments, you are protecting Jesus' faith. You're protecting my faith. And when I tried telling him, okay, I need you to do this, he was like, well, I don't know that I have that power to do that. I said, check out Section 18 of the Notary Act. They're empowered to do anything under any statute, any duty or anything that is required to be done under any statute. They have the power to do it. Need a judge? Get a notary. Need a sheriff? Get a notary. Need a notary? Get a notary. When you point that out to them, you might have to do a little bit of shopping, but have faith, find one who is going to do what you want them to do, and if not, put them on notice. Serve them a notice of understanding and intent and a claim of right, because whatever that notary is doing, you can accomplish with 3 people from your community who are of good standing. 3 people can act as your witness, and what they create will have just as much power as any notary. So don't let them say, oh, I can't do that for you. You are doing it, or I'm going to write a snap nasty letter to the Notary Society. The Notary Society likes me in BC. They've even invited me to go and speak at one of their conventions, or when they get together. They lock horns with the Law Society all the time. The Law Society hates them, and they like how I've been empowering them. And they've had lawyers, like I had Kwan, he said that he got a phone call telling him that he couldn't do these things. I said, tell him you want it in writing. Never heard back from them. They aren't going to... And the reason is, I'm sure many of you have read court rulings from the Supreme Court of Canada. In a free and just society, this might be acceptable, Ask yourself this. What's the name of your society? Do you have one? There's a maximum law that says, if you know not the name of a thing, all knowledge of that thing must perish. If someone tells you, I'm going to my best friend's house, and you say, really? What's your best friend's name? And they go, do they even have a best friend? Believe it or not, any member of a society, every member of a particular society will all do the exact same thing if you ask them the right question. If you ask them, what is the name of your society? Every member of that society will say the exact same thing. Societies have names. In British Columbia, it's the Society of Notary Publics of British Columbia, the Law Society of British Columbia. If you are a member of a society, you will have a card. Your picture will be on it. It will have evidence that you've been paying your dues, and you will be able to tell me the name of your society. Now, if you can't even tell me the name of your society and you know a statute is a legislated rule of a society which has been given the force of law, and you don't have a society, why do these acts have any force of law over you? Believe it or not, all of these statutes, they are a legislated rule of a particular society which had been given the force of law, but that's the law society. All of these rules are the rules for the law society, and you can prove it. Only they can make the statutes, the regulations, or the orders. You are not allowed to pen these. If you go into court, they claim that only they may use these documents or these words, only they can claim complete understanding of these words. Unless you're a member of that society, you cannot understand these words. Why? Because societies have a number of powers. As a society, you can generate and create your own rules, and no one who is not a member of that society is going to have a say in creating those rules. You can claim that no one but a member of that society can understand those rules because you can actually create your own language as a society if you want.